Live on YouTube. Okay, let's go on the record on cause number DC 2012084, Canterbury Cove LLC versus THB Construction LLC. Council, make your appearances.
Sean McCafferty on behalf of plaintiff Canterbury Cove LLC.
And Madeline Hayes on behalf of THB Construction LLC and Travis Boney.
Okay, let's go ahead and proceed.
Morning, Your Honor. This is a case that's got, well, two corollary motions. One is a motion for summary removal of a lien, and then the other is in the alternative, a motion for summary judgment on the quiet title claim to invalidate the lien under that theory as well. I'll proceed under the summary motion procedure first, if it's okay with you. They're very similar arguments, obviously. We believe that the summary removal procedure is appropriate in this case because there was essentially a false lien filed on this property by the contractor. It's a false lien because the amount is materially and drastically overstated as established by the evidence that was submitted with the summary motion, as well as the affidavit of the owner of Canterbury Cove, Bart Reeder. And there are several things that were in the response that were undisputed that clearly established that the amount is inflated. For instance, one, there's no evidence to the contrary of this in the response, and the only evidence is that there was no maintenance bonds on this property purchased in the amount of $21,273, yet that amount is included in the charges.
Mr. McCafferty, so I've read the briefing on both sides.
Sure.
It's very well done. No surprise, both good law firms. But one of the arguments that Ms. Hayes raises in this case is that there are, I believe, 7 grounds that you can invalidate a lien. 6 of them don't apply at all, she's according to her briefing, I think. And the other one does also, I don't know how to put it, but doesn't also qualify in this situation. So, what is your position on that?
So there are 7 grounds under the statute, one of which is that the contents of the affidavit is inaccurate. And our argument to that is essentially, in this case, the contents of the affidavit as sworn under the affidavit submitted with the lien is hyperinflated by a significant degree. We believe there's only $12,000 owed, and they have filed an affidavit for $370,000. There is there's
a Dallas Court of Appeals case. I think it's the Gibbs case. Is that right?
The Gill case, yes.
Gill case.
Yeah. And that case is interesting. Shockingly, I was surprised that there's just not enough law on this. There's not very much law out there on this issue. But that case, we think, is limited to its facts and actually sort of supports the notion of the property code saying that an inaccurate amount, if it's material, can be a basis for removal. In Gill, it was a different situation in that here we have a contractor placing a lien on the property of the owner, and the owner contesting the amount of the lien is dramatically overinflated, and using the removal statute for its intended purpose to make sure that the amounts actually subject to a foreclosure in the lien are accurate and correct. In Gill, it was a case where a third-party lender foreclosed a year after the lien had been filed and had full notice and knowledge of what the lien, that there was a lien, bought it anyway, and then refused to pay the lien, and argued ultimately that there wasn't a secured interest because the lien amount was overstated. And the Court of Appeals said, and they specifically use this language, and whenever I see this language in the Court of Appeals, I think they're trying to limit it to the facts of that situation. They said, under the facts of this case, the lien amount being higher doesn't matter because the bank bought it anyway, and that they knew that there was a lien there. And so for purposes of what the lien removal statute and the lien protection statutes are as to third parties, they had noticed that there was a vendor with a claim out there, and they bought it anyway. And so they had to pay ultimately the amount that was reconciled at trial, the lower amount, but it still qualified as a secured claim.
Are there any cases out there that have invalidated a lien because the lien amount was incorrect?
I cannot find one, Your Honor.
Okay.
Yeah. And so our position is that the statute text says you have to have a sworn amount, and the word amount has to mean something, and it has to be, and because it's supposed to be sworn, it's supposed to be the correct amount. And if THB's construction is correct, they would be permitted to file a $3 billion lien and argue, hey, you have to pay me $3 billion or the amount, whatever ultimate amounts they say. And the prejudice and effect on what that may do to the owner and their ability to finance, continue on with the project, those types of things is much more out of whack and out of balance. And that's why we think that a reasonable construction of the statute, which frankly, if you look at the text of the statute, doesn't say it can be anything other than the amount, which is the amount due and owing, means that they have to prove the actual amounts owed are correct and tied to the amount they claim in their affidavit.
Where would you draw the line if the lien is overcharged by $1? Would that be a grounds to invalidate it? If it's off by $1,000, off by $100,000, where do we draw the line here?
Well, I think the answer is, like all the cases in these types of cases say, it's a case by case factual analysis, and you would have to look at the prejudice and the reasonableness of the charges associated and the basis for the claim to the charges. And here, like I said, there were 3 instances where, at least in the response, there is no answer of about $50,000 of charges that are included that we believe are completely improper overcharges. The maintenance bonds for $20,000, excess concrete for $15,000, phase 2 retainage when phase 2 hasn't even started yet of about $12,000. And then of the 3 pieces that they try to defend, there are valid claims that make those things not due and owing at the time they filed the affidavit, which means it's not in a sworn amount. And so that's a really tough question, Your Honor. Obviously, is $1 improper versus $1 billion improper? I think obviously it's easier at the extremes to make that call. Here, the summary judgment evidence, the summary motion evidence, we believe establishes that it's overstated by $350,000 roughly on a $370,000 lien. So virtually the entirety of the lien is improper in our opinion, and we believe that the evidence supports that.
So let me ask this: there are 2 motions you're bringing. One is the summary removal of the lien. The second is a summary judgment.
Mm-hmm.
In the 7 grounds that were discussed by Ms. Hayes relate to the summary removal of the lien only, or for both motions?
Well, the summary judgment motion was brought in the alternative on the quiet title claim to remove the lien as a cloud on the title because it doesn't state an accurate amount. The argument made in the response is that a quiet title, one of the elements of a quiet title action is the claim on the title has to be unenforceable, which goes back essentially to the same arguments made under the summary motion. I think that's probably the correct legal analysis. We do think, though, that the summary judgment evidence establishes that the amounts that are due and owing under the lien are not the $370,000. It's closer to $12,000 when you do the math. And
are there any cases that have allowed a quiet title motion to be dismissed or a quiet title claim to be granted where there's a dispute over the amount of the lien?
I do not recall off the top of my head, Your Honor. I think we cited to a quiet title case that had to do with the removal of a lien, but I don't remember if it answered the question that you're asking. So I'd have to go back and look at the briefing on that, to be honest.
Okay.
I think it's close. I don't remember.
Ms. Hayes?
Yes, Your Honor. Your Honor, just like the response said, it is Canterbury's burden, not THP's burden, for a summary disposition motion under 53.160 to convince the court that we did not comply with the statute, that the contractor did not comply with the statute. Canterbury has not met their burden. After doing some research, the only case somewhat on point was the Gill case. And honestly, even though the facts are slightly different in Gill, the overall holding is the same. Gill in that case was asserting it is not unreasonable for the law to require that amount be correct, or at least much closer to correct than the amount stated in International's affidavit. And then the court held, we hold it does not. This is a statute that gives contractors, it's supposed to be construed liberally towards a contractor. And we're not saying that the amount, we're still disputing the amount. We believe that the amount is correct. And it's just, there's other remedies that Canterbury can go after, but this is just not the proper legal mechanism.
What remedies can they pursue besides this?
They could bring a different type of summary judgment motion. We could go to trial. There's several different, actually, those are the two that I know of off the top of my head. I just know that 53.160, there's a time and a place for it, and this is just not it.
Could you share screen the Gill case with me?
Yes, Your Honor. Your Honor, it says host disabled participants.
Oh, oops, that's my, let me fix that. Go ahead. Let me see.
Are you able to see it?
Yeah.
Okay. And Your Honor, I've highlighted the applicable sections here. It's a very short opinion. But as the question before the court was, they were looking precisely at the issue that we have before you right now, which is, did the trial court err in finding that International had a valid mechanics and material lien because the lien affidavit stated an amount far in excess of what is owed? And again, Your Honor, we dispute that, the parties do dispute that the amount stated in the lien affidavit is in excess. We believe that the amount stated is correct. But even if this court finds that it's not correct, still this court held that the lien was still valid.
Okay. All right, I'm going to go ahead and deny the summary judgment and the motion to summary removal of the lien. I don't think that I have the authority to do that based on the law. So you can stop. Let me see. Go ahead and stop sharing. Anything else today, guys?
I think that's it, Your Honor.
No, Your Honor.
Have you submitted an order on this, Ms. Hayes?
Yes, Your Honor.
Let's see. Does it cover both motions?
Yes, Your Honor.
Let's see. Make sure we have it here. Do you know what day you submitted the order?
Great question, Your Honor. I
see it right
I think
here.
it was the second.
Yeah, Rhonda, if you could go ahead and print this out. It's on August 2nd, 2021. It's proposed order denying. Is that what it is right there, I assume? All right, she got it. Okay. Anything else, guys? When are you guys set for trial?
I believe in November.
Yeah, November, Your Honor.
All right. Have you been to mediation already?
We have.
Yes, Your Honor.
Okay. Well, hopefully you guys get it worked out. If not, we'll see you, I guess, in November 9th. Okay.
All right. Thank you, Your Honor.
Thank you, Your Honor.
You guys. All right.
Take care. Be safe.
You be safe.
May I be excused?
You may.
Thank you.
Okay. All right. So let's chat real quick. Our next hearing is not until 10:30. So let's first off, let me go ahead and turn this off.